And good afternoon, everybody. This is Vinny Maletti with Maletti Law, the strongest name in the law. The date now is September 6th, is Labor Day. Happy Labor Day to all of you. Now, clearly, Maletti Law is still open on Labor Day, and, much like every other day, I feel like we're just always on all firing on all cylinders. All right, so let's begin. First of all, number one, to get this started, you need to click the link below and subscribe on the YouTube channel. Please go sign up to the newsletter. We're getting heavily censored right now, which is pretty funny. I'm now practicing for quite some time. I have never had this amount of censorship before from YouTube. YouTube actually shut my page down for a moment not too long ago, which is pretty funny. And then they limited it to just like whatever, one video. But I've never had this before, so I would strongly urge all of you that if you want to keep being informed about all this content, I really would encourage every single one of you to go to my website, malettilaw.com, and sign up for the newsletter as well. Subscribe here below. I will constantly try to drive as much as I can out to you. A couple big developments. We do have a GoFundMe. If you happen to be like a nurse or somebody that's working in the medical profession, that you're about to be canned from your job that you've had for a million years because of the vaccine policy. Certainly, we have a fund now, so which is good that we could help, meaning that I'm not doing this all for free, so it's nice. I appreciate that. But I've also, dropped my rates on tremendously, so I now have a lot of bandwidth. I will have bandwidth as long as people keep donating a little bit. There'll be plenty of bandwidth where I'll be able to actually feed my families as well. Feed my family as well to be able to do this. So it's all together. We're going to do this all really well. So that's a good thing that's taken off and it's been going. So I appreciate that. So part of my commitment to you, I want to obviously disclose everything. I want to make sure you're all well informed. This video is going to be really quickly. This is more of the Q&A training. So in part one, we had the anatomy of a disability discrimination claim. In the part one, right? It was the anatomy of a disability discrimination claim. So what was our context, right? Going back to our situation was we had somebody that was an employee for a very long time as a nurse, maybe 20 years. The vaccine policy rolled out. She's obviously against the vaccine for specific reasons. She has medical issues because of a pregnancy, whatever the case is. And so now they're saying, well, too bad, we're not making any exemptions and you got to go, right? So obviously that's not going to happen. Even the mandates, even the executive orders, they all say you have to pay attention to ADA, Title VII, stuff like this. Like you have to pay attention to disability laws. So that's not correct to begin with. But in order to help understand how these processes work, I started with what's known as the anatomy of a disability discrimination claim. This way so you can get a level of familiarity with what to do. So we started in the first video by just kind of walking through what the elements were, right? What you needed to show. How do you qualify? You qualify by showing that you suffer from a disability. In that situation, it was pregnancy-related conditions. That you had suffered some adverse reaction because you suffered some adverse reaction, whether it be termination from your position, suspended, whatever. That you were qualified for your position, that you had no other issues, you weren't a bad nurse, or you weren't bad at your job, you didn't have performance issues, like you had some other, like you were just qualified at what you did. And then the fourth item that everybody needed was that the discharge or the adverse action needed to occur under some circumstance giving rise to this inference of discrimination based on that disability. That is a very, very fancy, complicated way to just say that the adverse reaction you suffered was by some way, shape, or form connected to what you're complaining about, the disability discrimination. So New York here's what's new in this time around. New York has specific rules for pregnant women, okay? So whereas like Title VII didn't particularly speak about pregnancy, you did have the PDA, the Pregnancy Discrimination Act, which was an addendum for it to tie into it. New York has their own specific codes in Section 296 of the Executive Law. What is the other one? I can't remember the other one. The other one is like the Administrative Law, Section 8108 or something like that. But Section 8107 1A. So you have specific laws, so you're protected. You're definitely a specific protected class in New York. So all right. So as you go through the framework, right? So remember, you suffer from a disability. You were discharged, whatever the case is. You had an adverse action. You were qualified. So now we just kind of look to this final element, right? So the final element is that the discharge occurred or the adverse reaction occurred on some inference of discrimination. So again, very fancy language. You're just tying the adverse action you suffered to the incident of discrimination you're alleging. You terminated me because of my pregnancy. Okay, how do we bridge that gap? You terminated me because of my disability. How do we bridge that, right? So the law permits this to happen in I see one of three ways here so far, what it seems to be. So what happens, the law permits it in direct discrimination, indirect discrimination, and then there's a concept of disparate impact. So direct discrimination is very easy to, direct discrimination is, if you have it, you have it, right? So, your manager comes out and says, man, I hate all these disabled people, man. They're so bad. I want to get rid of all of them. Oh, that's a great example. All right, you got to go. Here's a policy, you got to go, right? Something like that, obviously, it never happens. We live in 2021. No one walks into the office in the morning and says, oh, man, I really want to discriminate against all these people. Doesn't happen, right? So, so that's that part. Then there's indirect discrimination. If it's indirect discrimination, direct could be shown in either intentional or circumstantial. So for instance, an intentional direct discrimination is like we were just speaking about. A circumstantial but direct discrimination is something like suspicious timing, right? Ambiguous statements. So let's just say suspicious timing. Let's say suddenly you just kind of like tomorrow you find out you're sick and you have the disability, and then a week later you get termed. You get let go because of some policy statement that happens to address your disability. So that's that suspicious timing element. We see this as proximity is what it's another word it's called, but that's that suspicious timing. So that's more of circumstantial. So remember, you have direct, which has direct discrimination could be shown either intentionally or circumstantially. Then you have an indirect discrimination. Here's where we have this framework known as the McDonnell-Douglas framework, right? McDonnell-Douglas. So McDonnell-Douglas was a Supreme Court case that was introduced in which they created this framework in how you play volleyball essentially with the employment law, right? So think about it as a volleyball game, right? So here comes the plaintiff, here you come, here's the nurse. So the nurse wants to get on the court to play volleyball. She needs a prima facie case to play volleyball, meaning she needs a case in the face. She needs those four elements to play volleyball, right? So those four elements: does she suffer from a disability? Did she suffer an adverse reaction? Did she qualify to hold a position? And, was the discharge connected some way, or can she at least allege it some way to, was the adverse reaction connected some way to the disability, right? Have all four elements, you're allowed to come play ball, you get the volleyball, you put it up, volleyball goes over. Now, employer gets it. Employer has to hit the volleyball back. Second part now of the McDonnell-Douglas framework. The second part is now the employer has to articulate some specific legitimate non-discriminatory reason for why that employee suffered that adverse reaction. So now the employer gets the ball, says, you know what, well, I only did this because the government told me to do it. Hits the ball back, and now falls back on the other side. So now the employee has to come back around, has to say, your response was merely a pretext for behavior that's actually motivated by discrimination, right? So the employer now is saying, okay, your response was pretextual, it was false, it was canned, it was made up, you just sent it to me, that's what you're doing to try to like weasel your way out. It really was motivated some kind of discriminatory animus, right? So, okay, well then how do you show that discriminatory animus? And this is where we go back to, is it direct, is it indirect? Can you show that they directly were like, you know what, this is a great idea, we should use this as a launch pad to get rid of all these people? Or is it circumstantial? Again, timing. Timing is really good. This would be a great time. Timing is really good. We should let this happen. It's good to, getting rid of some of these people off our books that we don't want. Circumstantial. So there's another one called disparate impact. If a policy in of itself, even though it's facially neutral, hey, I only do it because the government tells me to do it. Hey, the government mandates this. If the policy has a disparate impact on a particular class of people, then that in of itself is a big deal. So that in of itself is a big problem. So disparate impact cases, they're a little bit harder to show, but I mean, it gives the opportunity for you to say that. It gives the opportunity for someone to say that, okay, it might be facially neutral. It might be, the specific policy of practice might not speak of any kind of disability or any kind of class or any kind of classification, but there is a disparity within the actual just within the actual language of the policy itself. That disparity only affects nurses. Only affects pregnant people. That disparity only affects African Americans. That disparate impact only affects men or only affects women, right? So now, I mean, again, so you hit that back, poof, has disparate impact. Poof, employee gets the ball back. Now we start the process again. The employer has to come up with a business reason to show, a job-related reason to show why, a business reason to show why that policy was needed to be in effect, why they had nothing else in the world they could have done but follow that policy in order to preserve their interest as an employer. And that's really, that the ball goes back and forth at that point, but really with the other picture, what I'm trying to say is that that's really the McDonnell-Douglas framework, is this valuable game back and forth, that bounces back and forth between the people. So today's big rules, what we're gonna the big takeaway from today in our installment of the anatomy of a disability discrimination claim. Today's big thing that we learn is just simply how do you show that fourth element? How do you show that connection between the adverse reaction, the adverse effect that you suffered, and the discriminatory element that you're complaining about, right? So how do you get there? How do you bridge that gap? You bridge that gap by showing direct discrimination, whether it be intentional, circumstantial, indirect discrimination, whether it be disparate impact or some kind of disparate effect that affects a whole class of people. And it could be on its face, it could be some kind of mixed motive, whatever the case is, but that's essentially how you do it. So once we get to, it winds up becoming, like I said, it winds up becoming a valuable game. It's who can keep hitting the ball back over to each other and who could actually make the point. The law is the law is there. So that's really where we have to go right now with this. In the next video, which is probably going to be the final video on this, I do want to have kind of like a best practices checklist for everybody that is going to take this position for anatomy of a disability, to have a disability discrimination claim, kind of like a checklist of things you need, right? So you definitely need a doctor that's willing to write the documentation. You definitely need to put your employer on notice. Everything should be in emails. You should definitely convey convey what you need to speak to people about, convey your discussions accordingly and properly. So that'll be in the next video. In the next video, I'm going to provide a checklist on best practices and the critical steps that you need to have in hand in order to bring a discrimination claim. In Mars, specifically pregnancy discrimination. If you have any questions, concerns, by all means, let us know. You have our information. Go to the website, contact us, click subscribe below. I need you to subscribe. I'm going to be banned very shortly, most likely. So please, let's be connected. Join the newsletter also as well, because it's my website, so no one tells me crap. All right, everybody. So have a beautiful day, and we will keep pushing and try going until we get this over with.